Chase Manhattan versus Josephson case, or Maryland National versus LittleJohn, which was the actual legal services case, is a great example of the way that a little case can become the big case, and that it's so important that we work together and coordinate the work that we do. This was actually the second case. The first case had been Guttenberg. What this had to do with, it was around whether or not an individual could automatically be evicted from housing when a property was foreclosed and a new owner purchased the property at sale and took over. And initially in Guttenberg, the Supreme Court said yes, that they could be, that the tenancy terminated, that this new owner had no obligations under that, and that the tenant wasn't protected. Thanks to advocacy through legal services and others, the Anti-Eviction Act was changed. The language was changed to hopefully provide that protection that wasn't there before. And when this tenant came in to see me, she was being evicted from her home in Newark, along with her daughter and her granddaughter, because the property had been foreclosed on. It was a single-family home. The owner came in, he took their money, he didn't pay the mortgage, he skipped out, and they were stuck. So I intervened in that, argued that they were protected as tenants, and that they couldn't be removed, that the new owner still had to follow the Anti-Eviction Act and could only remove them for grounds under the Anti-Eviction Act. That case was then consolidated with Chase Manhattan versus Josephson, which was a case that was being handled by the public advocate at the time. So I coordinated with, and we coordinated with, within, at that point, Essex Newark, really coordinated with the public advocate so that our briefs complemented each other, that we were not making contradictory arguments, filed our appeal on those. We were denied at the trial, court and chancery court. We appealed that, denied at the appellate division, and ended up then in the Supreme Court. And at that point, really involved other programs, came and met at LS&J, just try and strategize, what are we going to do, how do we approach this case. I was a pretty new attorney, and Dee still absolutely listened to what I was saying, listened to my thoughts on the case, listened to my arguments for why I thought the court in Guttenberg really decided the way they did, what we needed to do differently in this case, that this wasn't just a matter of parsing out and interpreting this one little new section of the statute, but it was about convincing the court why this was the right thing to do for policy reasons, and why requiring new owners to continue to rent to tenants in place was not the death knell for the housing market and the housing industry, which was the claim of the Bankers Association and others. And so was able to work really closely with that. LS&J took on amicus for that case, and we were in contact daily for a period of time about that. LS&J was able to provide resources and research and information and arguments in their brief that were very different than what you could do as the moving party. And so we were able to, again, complement each other's work, but also really present this larger, more comprehensive picture to the court than what they could have had it just been a brief from me and the public advocate. And ultimately then we were successful on that. My client moved out of the property 2 weeks before oral argument. So we had to disclose that to the court, and that case ended up being dismissed. So Chase is the case that's reported, but it was really a combined effort.